Let's start with our next panel. Thank you all for joining us. In case you weren't with us at the top of the previous panel, I just want to say that if you've given us a submission, we've read it, we've considered it. Please keep your comments to 5 minutes. I'm a little bit strict on that just because the conversation is really the most productive piece of the panel conversation. So I will cut you off as gently as possible. But really do keep your comments to 5 minutes. Really appreciate your time. We'll have about an hour total to talk. So our panelists today are Dr. Garen Wintmute. Is that correct?
Yes.
All right.
Thank you.
Thank you. I'm horrible with names. He's the director of Violence Prevention Research Program at UC Davis. Julia Weber, who works for the Giffords Law Center to Prevent Gun Violence. Marissa McCowan, who's a deputy district attorney at Santa Clara District Attorney's Office, and Michael Vidmar, who's also at the Santa Clara District Attorney's Office. Thank you all for joining us this morning. Dr. Whitmute, can you kick us off?
Sure. Hello, everybody. Thanks for the opportunity to speak. 3.5 topics in 5 minutes. The first one is regarding purchase restrictions and not retrieval, but the information is relevant. We years ago took advantage of a state policy change to deny purchase of firearms to people convicted of violent misdemeanors. We did one of very few controlled evaluations of a policy with data at the individual level. 2 groups of violent misdemeanants tried to purchase handguns in California. One group under the old policy got their handguns. The next group in the first year and a half or 2 of the new policy did not get their handguns. The groups were very similar. They all had misdemeanor violent convictions, and they were similar in many other ways. We followed these people forward in time looking at arrest records. The group that was denied the purchase of a handgun had an approximately 25% reduction over the next 3 years in arrests for violent misdemeanor crimes. And adding to that, there was no difference between the groups in risk of arrest for crimes of other types, a specificity of association that helps us infer that the effect we saw was due to the policy. So that's acquisition prevention. Now to retrieval. Restraining orders. I'll mention gun violence restraining orders and DVROs both very briefly. We do not have formal controlled evaluations at the individual level on either one. For gun violence restraining orders, we have some population level studies. We have some use studies. The use studies include one case, one study in which these orders were used now 58 times in our data in efforts to prevent mass shootings here in California. None of those mass shootings occurred, 0 for 58. How many of them would have occurred if orders had not been issued? We don't know. I'm not interested in conducting that sort of randomized trial, quite frankly. There have been some other use data suggesting that if we look at suicide, not your primary area of interest, 1 suicide is prevented, 1 life is saved for approximately every 20 orders issued. And there are 2 studies converging on that number of 23, actually. As a physician, if somebody told me I had a new medical intervention with an NNT of 20 and the outcome was saving a life, I would be wildly excited, just to put that estimate in context. That's very effective. DV restraining orders, we have probably the best data comes from April Zaioli and her group looking at the population level, the effectiveness of having such a policy in place. They work if and only if the policy includes firearm retrieval mandates, the policy includes extends to include boyfriends, the policy extends to include temporary restraining orders. We do all of that in California already. I'm going to defer to Julia and others about recommendations for further policy. Finally, apps. I listened to the prior panel. We're evaluating apps. We're actually doing a statewide randomized trial of apps with data at the individual and at the population level. We do not expect apps to show a decrease in crime rates at the population level because the people that the prior panel was talking about, that small group of high rate offenders, are not known to apps. To be known to apps, you have to be buying guns legally, and the people at highest risk are not there. Apps is going after people who, relative to that small group, are at lower risk. At the population level, we're not expecting to see an effect, and we have preliminary data that I base that expectation on. The money's at the individual level. We're looking in a randomized way at the impact of having firearms recovered through apps on an array of outcomes: arrest, suicide, et cetera. I'll stop there.
Perfect. Thank you so much. Ms. Weber?
Well, good morning, and thank you for inviting me. As I'm Julia Weber, you have my bio. I'm appearing today as a consultant with Giffords Law Center to Prevent Gun Violence. I established the implementation program there and now work as a consultant for the organization and for several other organizations. What's weighing heavily on my mind, of course, today is the terrible, tragic mass shooting in Alameda this week, where a father reportedly killed his wife, his in-laws, his 6-year-old child, and his 1-year-old child was shot and is in critical condition. There are going to be a lot of questions, of course, some of which relate to some of what we're talking about today. What we do know, of course, is that the combination of domestic violence and access to firearms increases the risk of lethal outcome by 500%, and that 2/3 of mass shootings have some kind of connection to domestic violence. So we have good policies in the state, and Dr. Wintemute has referred to some of those. I would, again, it's in the title of my history, working on implementation issues, further emphasize that what we need to be working on is robust and fair implementation of those policies, which can be addressed, I think, through changes in our penal code, which is a focus of your work, of course. And I was with the Judicial Council for 17 years.
I'm going to stop you right there.
Yeah.
You hit exactly where we want. I normally don't interrupt. What are those changes? Like, this is what we want.
Exactly.
What are the changes in the penal code that you think could help with the implementation? You said that's
Well, I provided an extensive list in my written submissions, of course. So, and that's what I want to sort of go into. So in my work, and that's what I'm going to cover briefly in my remarks, and I've set a timer, so I'll also attempt to stay within those 5 minutes. But what I see working, and I get to see this all the time because I'm consulting with organizations and I'm in courtrooms and I was with the Judicial Council. I see informed judges issuing well-crafted orders where someone's contemplating suicide and threatening their partner, and the order is issued, the person understands the order, the court communicates that they need to comply, and that person complies by turning in those firearms, gets the help they need without heavy-duty law enforcement intervention. But that order was served by law enforcement. Law enforcement did what they needed to do to serve that order, to retrieve firearms, and there was follow-up for additional firearms that may not have been relinquished or retrieved at that time. That's something that's working in some jurisdictions. And where it's not working, we need to do things like take existing rule of court, Rule 4.700, which was adopted in 2010, and elevate that rule to a statute. Part of what SB 899 does includes some of that work, but that's a rule that says that courts are required to have review hearings. Criminal courts should be having those review hearings to ensure compliance. But a key element, we've seen this work, is SB 320 on the civil side. 3 elements. Number 1, people need information about how to comply. It seems obvious, but we in California, the first state to include that kind of provision, which is not just information that you are hereby prohibited, but here's what we expect locally in terms of relinquishment. Here's how you can do it. We've seen a huge uptick in compliance just by providing that kind of information. We need to do the same thing in the criminal context, where we have even more opportunity because we have attorneys, which aren't always available in the civil context. We have probation's involvement. And in domestic violence cases under Penal Code Section 1203.097, we have batterer intervention programs. Batterer intervention programs, 1203.097 says nothing about firearms. We need to update 1203.097 so that it clearly talks about intake, screening, safety planning, and compliance. in domestic violence cases around firearms relinquishment and prohibitions. So there are changes that can be made there. There are changes that can be made to Penal Code Section 18250 so that law enforcement's retrieving firearms, not just in GVRO and DVRO cases, but across the board. We have workplace violence prevention, civil harassment prevention orders, elder abuse, school violence prevention orders. We need to do a better job coordinating between civil and criminal. We need to hold our prosecutors accountable for taking violations seriously. I'm glad Santa Clara is here. They're doing a fantastic job. And so we see in counties, in jurisdictions where they are taking the policy seriously, where they have the support. We need technical assistance, training, convenings. They need the opportunity to have the support and the sunshine on compliance, which means training, reports, convenings, and policies that reinforce doing the right thing at the local level, so we don't push it down the line, which is more expensive and more dangerous when we wait and don't handle this as close to the time of prohibition as possible. So thank you. Happy to answer questions.
Thank you. And I understand, okay, so now we're back, now we're down to the Santa Clara District Attorney's Office. Ms. McGowan and Mr. Vidmar, I understand one of you will be speaking for the office, at least, opening marks.
I will.
All right.
Hi, I will
Your
definitely
time
keep it to
starts now.
my 5 minutes. Great. I'm really grateful to see some of my friends on here. One of my primary comments about any implementation of any law that goes into effect is that the law means nothing unless people understand what it is, and there is a plan to implement it, and there is good education about how to use the laws and how to use the tools that are available. Super grateful to people like Senator Skinner who continue to pass really important legislation. SB 899 will be a massive gap filler for us. Thank you, Julia, for I'm sure your work on that. Which help bring other types of civil orders up to the standard of our domestic violence civil orders in terms of relinquishment and compliance. But my primary comments on what we've done as practitioners, because much like Sacramento PD, we're kind of where we're at the end of the line where the rubber meets the road, is the following. Number one, we need more subject matter experts in firearms laws within prosecutors' offices. This is something that I think is urgently needed. I will be working with my colleagues with the California District Attorneys Association to have more subject matter expertise in firearms laws. But we are one of the few DA's offices that has a team that focuses on firearms laws. They are complicated, they change every year, they are numerous, and in order to make them have any force and effect, we have to have a strategy to implement them. So you can't do the implementation if nobody knew that the law was even in effect. So subject matter experts across the state. Part two is immediate relinquishment of firearms is your best chance for getting guns. So if we have a civil order that is happening, weeks or months after the incident that led to the dangerousness, we're going to have to now re-engage with police teams to go potentially have a SWAT operation to go get guns back. So training officers to be alert to relinquish firearms immediately is a huge piece of what we train on. If you want to get the guns safely, do it at the time of the incident when you already are engaged with a suspect. It's your most safe and likely chance of getting guns. And so that, again, is a training issue. It doesn't require any more laws. I know you're the committee for the revision of the penal code, but stick with me for 1 second. And then the final point has to do with data integrity. Systems such as apps or CLETs or anything else requires, again, trained system users to be updating data immediately and correctly. So the Armed Prohibited Person system has tons of errors because we are not updating the AFIS, the automated firearm system, when a gun is actually recovered. So frequently we are wasting law enforcement resources to go out and recover a firearm that is already in police custody. This is a data integrity issue. This is a training issue. This is not something the Penal Code Committee can do, but I'm telling you, it is what leads to lack of implementation is bad data. So if I had recommendations for the Committee on the Penal Code, my number one recommendation would be to continue to support things such as SB 899, which emulate SB 320, which is to create opportunities and tools for practitioners such as myself, police officers, and others to have referrals if there is a failure to relinquish, to have relinquishment hearings that are mandated, to have commanding language for courts about you shall inquire, you shall check this system, so that it informs the actual practitioners of what their obligations are to care about removal of firearms. There are best practices in the field among practitioners, but unfortunately, we are siloed, we don't meet regularly, there are not opportunities for regular sharing of information about how implementation has been going or failing. So one of my big wishes for the state, which can't be solved by the penal code, is that those who are practitioners have an opportunity to inform policymakers about where the breakdown has occurred. I'm really grateful to have had the opportunity to regularly speak to committees like this about where there's a gap, but that is not true of most counties in the state, that we have subject matter experts who can provide informed feedback about the gaps in how things are actually working. So grateful for the opportunity to speak to you all. SB 899 is like my dream wish list. I have nothing else this year that is a huge gap filler in the penal code, because in my mind, it is not about writing more laws. It's about education, subject matter expertise, training, and uniformity among all of the people in this space, because it's simply not happening. We don't get together as often as we should, and therefore all the lessons that we have learned are not shared, and we could really improve one another's work. So thank you to those of you who have revised the penal code so that we practitioners can use it and train one another.
Thank you all. Let me just echo what you were saying generally, and that implementation of laws, it's one thing to pass a law, it's another thing to implement it effectively, and that's a huge challenge. And I think that's something that we should, as a committee, circle back and think about, and on lots of different areas. I see Senator Skinner has her hand up, so I'll start with her.
Thank you. So I think many of you, but maybe not all of you know, I authored the very first GVRO law. And California was the first in the nation to do that. And I did that back in when I was in the Assembly in 2014. And subsequent to that, I've done various tweaks to the law, plus other colleagues of mine, like Assemblymember Ting and all, that added things like the schools and workplaces and various other things. Anyway, so I'm in my last year in the Senate. Not only last year, we're talking last month, more or less. And a year ago, I became obsessed because I follow Professor Wintemuth's reporting very closely, his research, and also Ari's DOJ's releases on information of how much our different firearm relinquishment orders are used. And, you know, the law, the 2014 law went into effect in 2016. And I found that in the first, say, 5-6 years, it was basically hardly ever used. And the only jurisdictions where it was used were places like San Diego County and Santa Clara. And why? Because somebody, whether it was a DA's office, a city attorney's office, or the police, some entity in those areas decided it was a very important and useful tool, and decided to bring the different parties who have to cooperate together to make it useful, bring them together and make it useful. And that's where, and so we've grown some in number in terms of the use of these orders, relinquishment orders, but nothing to what they could be. And so, you know, it was more than a year ago, my obsession being the author, that, you know, what good was this law? I've gotten national awards for it. California is, you know, our governor, everybody talks about its importance, and yet it's not being used. So I undertook an effort to start reaching out to our police departments, all my local police departments, of which I have like 14, and to our city attorneys, to our DA, everything. And I was blown away how few of them, the lack of knowledge was astounding. And they all knew about a domestic violence restraining order, and they all just defaulted there, but none of the others. And in fact, we've had situations where one of my school districts felt that there was a student who was making credible threats, and they called their local PD to try to get a school order on this young person. And their PD responded to them, no, we cannot issue it because he's a minor, and as a minor, he can't own a gun. So basically, this school district just gave up. Nothing happened as that we know of. So, but anyway, so I started to undertake a series of workshops with my local police departments, with our school personnel, with many, and Julia from Weber from Gifford Center has participated. We've used materials from Dr. Winnemitt. We tried to get our Santa Clara partners a couple of times because we knew that they would be really excellent contributors to that. We had one jurisdiction, Alameda, where unfortunately this mass shooting just occurred, that embraced these relinquishment orders, and their city attorney and their PD really have embraced them and worked together and are utilizing them somewhat. But obviously this family in Alameda didn't know about them. But not only were the people who are responsible for implementing the order basically clueless about it, the public at large has no idea that this is available. So in my mission, I'm doing more of these workshops. I am doing a mailer to my constituents. I'm doing a variety of things, but now this comes to the bill that everybody's referencing, SB 899, which I'm doing now. And that bill, what it would do is mirror the way the court deals with these orders in the same way that the domestic violence restraining order deals with firearm relinquishment. In that, and I think it was described, that the court, in issuing a DVRO, the court says to the individual who it's issued on, relinquish your firearms. And more commonly than not, they do, and then the court follows up. And this, while there may still be necessity for law enforcement to go and retrieve the weapons, one of the things that we found is that our local law enforcement does not want to retrieve weapons. And I say that not to point a finger at them, but to be, if you look at the data, that is the time they are most at risk. That is the time when law enforcement lose their lives. So they don't, and they bring the amount of personnel that has to be engaged to do such a relinquishment. It's usually for small PDs, it's a very difficult thing. So I think this question of implementation, we do have to, and it's not so much penal code revisions as has been talked about, but we do need to, 899 is obviously going to help, but I'm going to be eager to look at what else Julia is recommending, but we do need to do a lot. We have to think through what is the most practical way to make these incredible tools that we have now in California useful, available, and used. And, I've started my own mission on it, but I think it needs to be wider. At least the brochure that I mail to my constituents is going to be a template now for the entire state Senate, so other senators will be able to. But anyway, I'll stop there. But I think this issue of implementation is very, very important, and making sure that our police departments understand, that schools and others that would be the ones, and families and such, churches, that they understand how to use it, that it's available, is very, very essential.
I'm going to go with, first, Ms. Weber and then Mr. Vidmar. Thank you, Senator.
Well, thank you, of course, Senator Skinner. Your leadership has been so critical to the changes that we've seen over the years in California, and lives have been saved. Absolutely. I'm going to be really honest here about what I'm seeing on the ground. And that is, again, we have these policies, but it's hard to engender trust and confidence in the system when they are not implemented. So if it is perceived to be just a piece of paper, people are less inclined to pursue them. And unfortunately, what we've seen with SB 320 is in too many jurisdictions when there is non-compliance. Let's say the court does everything they're supposed to do, and they report, and this is a civil situation, civil DVRO, so I'm going to make it relevant to the penal code revision aspect of your work here. When those non-compliance reports are given to law enforcement and prosecutors, they're not being handled. They're not being addressed. They're dropping the ball in too many jurisdictions. In a handful of jurisdictions, we're seeing that protocols have been developed, that the prosecutors are doing the right thing because they have subject matter experts, as Marissa mentioned, because they have the training, because that work has been done. So for the purposes of looking at the penal code revisions and the criminal legal system, we have to hold our prosecutors more accountable. We have to hold law enforcement more accountable. We need to see the forms used. Bureau of Firearms 4546, that form, BOF form that I mentioned, needs to be in every courtroom. I've been on a mission for that to happen in civil and criminal courtrooms, that if there isn't possession, no longer in possession issue, that needs to be addressed straight away so that we don't waste resources unnecessarily. I have found very few people know about that form. So I'm seeing a lot of confusion, misinformation, lack of awareness, and then at times unwillingness to fully implement. And then in the jurisdictions where we are actually implementing SB 320, we have limited need for extensive law enforcement involvement. Or if orders are served, anything that is needing to be retrieved at the emergency protective order moment or at the time of service is retrieved. When people get good information, we've seen over 400 firearms relinquished in Orange County, thanks to the Superior Court's efforts, without significant involvement from law enforcement. When they're doing the knock and talk in Orange County to follow up on noncompliance, knock on wood, we haven't seen injuries to officers, and we've seen people comply. They're well trained and they're doing it at the local level. San Mateo just reported over 100 firearms have been retrieved across the board. Again, good information, compliance hearings, review of the file. That's what we need to see. And I would say people generally don't know about a lot of this policy. GVROs are one of them. GVROs don't name protected parties. They're an important gap filler. They're incredibly important. We're lucky to have that tool in our toolkit, but we've got to be looking at workplace violence prevention orders, elder abuse orders, as well as civil harassment and DVROs, which are there are many more incidents where there are threats involved, where you have to restrict someone's access to property, but none of them are going to be effective if there isn't follow-up when there's non-compliance. And that's where the penal code can really come into play, because the criminal legal system plays such a crucial role in terms of follow-up.
So I just very quickly, and then we'll get to Mr. Vidmar and Ari. You're saying that you would suggest a new crime for failing to comply with a civil order?
No, it is a crime. The problem, if it's a crime that nobody follows through on, if the report of non-compliance sits in a drawer, which is what we're seeing happen, or isn't made, or we have prosecutors saying, I didn't know it was a crime. I'm not sure it is a crime, or I don't have good information to go forward because I'm not well trained. It's a crime. It's been a crime for decades. Non-compliance, having a firearm in violation of a restraining order. But we're not actually following up. So what I'm suggesting is this is what you can do by code: require training, require convenings, require reports on how you're implementing the law, require data collection, require protocols be developed across civil and criminal courts. So those are policies that we could put in place that support implementation. So implementation certainly can cost money and can't always be handled in legislation, but it also can, if you only have we always say in the courts, if you have 5 minutes to handle the case, you can do the right thing in that 5 minutes, or you can do the wrong thing. Should you have 20 minutes to handle the case? Probably. We need funding, so we have enough judges, we have enough law enforcement, we have enough service providers. But even if you don't have enough, what you do with the time and resources you have can make a huge difference. And we have too many people not doing the right thing or not knowing about how to do the right thing with the limited resources that they have.
All right, thank you. In order of my screen, I have Mr. Vidmar, Mr. Freilich, and then Ms. McGowan.
Great. Thank you for the opportunity this morning. And I just wanted to follow up on a couple of the comments that Senator Skinner was making. A large part of the success that we've had in Santa Clara County as it relates to GVRO specifically, I would attribute to our educational campaign. And this is something that when Marissa was leading our team, really recognized as lacking and an important part of the process. When GVROs were, when they first became a tool, nobody knew about them, right? And as Senator Skinner mentioned. Unfortunately, in Santa Clara County, not long after those orders or those tools became available to us, we had a couple different mass shootings in our county. And I think after that, after we kind of take a look at what that impact had on our community, we recognized that GVROs were something that we were underutilizing. And Marissa made it an important part of her mission and our team's mission to get out there to law enforcement to make sure that they knew what was going on, what was available to them. Tell them what a GVRO is, why it is now available for their utilization. And we've made it a focus of our team of driving that conversation as it relates to GVROs. And so when we look at the success that Santa Clara County has, I think it's immediately related to our educational campaign, making sure that our local law enforcement agencies know that this is the tool. So we're doing it up front with the education. We do it on the back end as well. We run a weekly intelligence meeting related to firearm offenses in our county, and we're looking at whether or not GVROs or any of the other civil orders that are out there related to firearm relinquishment have been considered or utilized. So we look at it in the front end and on the back end to see if we can find an appropriate way to safely relinquish firearms. And then I also wanted to kind of touch on the timing of the implementation. And as Marissa pointed out, Santa Clara County, if you look at the numbers that already put out, a large percentage of our GVROs are the emergency orders. They are the ones that the law enforcement is obtaining at the time of the emergency, as Marissa brought up. That was the best time, in our opinion, for the safe relinquishment of these firearms. The farther down the road, the farther away from that emergency, the more challenging it gets. As Senator Skinner pointed out, the law enforcement is very hesitant to go out and retrieve firearms. And so when we have these non-compliance reports, those are removed from that emergency situation. We have a system in place to address these non-compliance reports, but it is time and resource extensive. So I just kind of wanted to put that out there, and happy to kind of follow up and talk about any questions anybody has.
Thanks. That's helpful. It makes sense. Ari?
Sure. So I wanted to speak to the idea of implementation and the challenge of this committee to develop specific recommendations to amend the penal code. I think a challenge, right, is that implementation has been uplifted so often, and I think really importantly as the magic wand need, and it's also happening right now in the legislature. There's a dozen bills focused on firearm relinquishment this year. Most importantly, in my opinion, the department's opinion, Senator Skinner's SB 899 to standardize best practices. So it is happening. I have some specific additional recommendations, though, moving forward is on protocol development. I think the penal code could, building on what Julia and others have already said, mandate that law enforcement agencies, prosecutors' offices, courts update and develop standard protocols for how they will implement the firearm relinquishment programs, bring them to the table with a mandate that says, learn the law, develop standard processes for, under AB 818, for instance, 2 years ago, domestic violence survivors have the right upon request to have their protection order served by any law enforcement agency in the state. That will be news to many law enforcement agencies still. I think, so for instance, a standard protocol that requires the law enforcement agency to implement that SB 899 would appropriately and importantly extend that to all protection orders. So a protocol that requires the law enforcement agency to sit down and
Can I interrupt you just for a second?
Yes.
In any area, forget about firearms or whatever, do you know of places in the penal code, and anybody can chime in here, where there are mandated these type of protocols of education of the law enforcement? So for example,
Yes.
There are for the
GVROs.
GVRO. Go ahead.
DVRO,
For the gun restraining order, and those are going to be amended this year, and also for some domestic violence order. I'm sorry if I was interrupting.
Oh, no, I was interrupting you, Ari, sorry.
the domestic violence area seems to be the area.
GVROs too. So it's not uncommon for the legislation to include that law enforcement needs to develop protocols. We haven't seen that same kind of expectation with prosecutors. So I would argue that prosecuting agencies need to be expected to participate in developing protocols. So all 58 counties and their local law enforcement offices have GVRO protocols. We did a review of that at Giffords. And similarly, we've seen that for, a couple decades now with domestic violence restraining order protocols for law enforcement agencies. But I think prosecuting agencies, I'd argue having public defenders, we've had very supportive public defenders help their clients comply and avoid unnecessary exposure to the criminal legal system and reduce risk for the community and for the defendants themselves. So, I'd say put some more protocol development in and around prosecution, batterers intervention programs, the whole criminal legal system.
Just to be more, this is
Please.
actually why I raised my hand, was to say this would be an important thing for this committee. In the context of gun violence restraining orders, the actual language that it required that law enforcement agencies to promulgate a policy that they shall consider the use of gun violence restraining orders at the scene of domestic violence. In the case of, I think, mental health was named. It was actually spelled out what the policy shall include. And that was really important for us because we use that as a springboard to go to the Police Chiefs Association and say, by the way, new law this year requires that you promulgate policy. We will consult with you, but also you have to do this. It's a mandate. And so you don't get to not think about gun violence restraining orders. And also it was just a great opportunity to educate. So you could do that in any of the rest of the firearm relinquishment context. But I do agree with the mandate for prosecutors. Not that I love to mandate things for my people, but I do. But you could say you shall review. And there's a few things, by the way, that come to the DA's office and I think go into a drawer. One of them is attempted firearms purchases by prohibited people. Those are sent to us by the Department of Justice. So you could say it is mandatory that you shall promulgate a policy to review those attempted purchases by restrained people or prohibited people. And you could promulgate a policy saying you shall review under AB 899. It's a gap filler that says now that the courts shall refer to a prosecuting agency when there's been a finding of non-compliance. Have a mandate for the prosecutors too to promulgate a policy about what you're going to do with that. Because right now it's just going to arrive on somebody's desk and they're going to not do anything with it. So I think that that's really, really helpful because it doesn't allow you to not have thought about it or to learn about it, and now somebody's going to be responsible for it. So I've often said at these convenings two things. Number one, the most important thing about implementation is having a champion in a county. And if you're asking the question, who is that in my county? The answer is you. And then secondly, that if it's not specifically somebody's job, then it's nobody's job. So if you don't say this is the job of the prosecutor's office, then they're not going to do it. And it's not because we're lazy, it's because we're hella busy. But if this is a priority of a legislator or the penal code committee, then make it a mandate.
Are your hand up still?
Yeah, then just building right off that, I think specifically I would recommend in the protocols to, this can be different ways, but specifically require that it be someone's job, that there be designated responsibilities placed on specific positions so that it is someone's job to do this. I think what we see so often, Marissa, you have taught me this so well. Again, if it is no one's job, if it is everyone's job, it is also no one's job. And so what we need so often is we have nation leading laws on paper. What we're talking about is how do we get that to show up consistently in practice so that our systems are safe and consistent at recovering firearms when they have adjudicated someone to be a danger to self or others immediately. And so what we need is someone whose job it is, especially with funding, to identify noncompliance, to provide all the tools to facilitate compliance and identify noncompliance, and connect all the different parties that need to be connected as stakeholders when there is noncompliance to actually recover firearms. One final point and so I think that could live at courts. I think it could live at law enforcement agencies, at DOJ. The idea is that we need embedded people throughout the state whose job it is to do this work and to be responsible for it. And then the third thing I will ask or add, and this is a bit more medium term, our firearm relinquishment program, the APPS program, for instance, as Dr. Winnemute mentioned, is focused on individuals who at one time legally purchased that firearm. We have 60 special agents, as Dr. Winman said, who are recovering firearms that people illegally kept, but originally legally purchased. Those are the firearms known to DOJ. But at least in the protection order context, we also have a lot of information provided by petitioners, like a domestic violence survivor, who goes into court and says, this person has 3 ghost guns. They used one to threaten me. Here's a photo of it and where it is. That may not be known to DOJ, and that person will likely not be on the app's subject list. But we can use the penal code, and it will require resources, but to amend CARPOS, to use CARPOS, to have dedicated people whose job it is to push out information that says the court received information that this person has guns not known to DOJ. The court made a finding that this person likely has firearms nonetheless, including illegally acquired ones, and that should be part of the firearm relinquishment processes too. So we're trying to do a better job both of recovering the firearms we know about at DOJ, but we also could do more using the penal code, amending CARPOS, and having people whose job is to push out more information about those instances in which we have credible information about other guns too.
Dr. Whitmute, I don't know what you were going to say, but I did have a question for you, so I'm going to ask you to integrate it into whatever you're about to say, which is, so we've been talking for the past half hour about better implementation of laws that are already in the book, restraining orders that are already in the books. Is there a way that you can quantify the impact that you think that might have? I mean, you did cite one study in your talk about, the significance of these types of additional restraining orders.
Yep. Excuse me. Sorry. So I'll say what I raised my hand for first and then answer the question. Sorry, suddenly I have to clear my throat. Preamble. I was going to make a bunch of Me Too endorsements to other things that have been said. I'm also a fan of celerity and certainty, and that's been stressed, I think, in all the comments. If there are going to be policies that include the verb shall, they should probably include the noun court along with others. There's nothing like doing it as part of a single transaction. To quantify, for years, it has changed in the last few years, but for many years, most of the guns that APS teams recovered were guns they did not know about until they hit the scene. A comment about implementation, we did ride-alongs for weeks with APS. All those people do is recover guns, but it's a lot of driving around. It's a lot of working up places. It's knowing the physical layout of a house before arriving. It's being on the lookout for an ambush possibility. A few times we drove away from what looked like a setup, and there are typically 6 people and 4 vehicles involved. It's a very labor-intensive process. We did an evaluation of firearm retrieval for D-Delta VROs in 2 counties. I won't name them. One was a rural county. 2 deputies went out. They were gun people. They said, "Hi, pal, here's your restraining order. Give us the guns right now." It worked well, although in their words, sometimes respondents ate concrete before the process was over. But there was an urban Bay Area county that, left to its own devices, developed a process in which non-sworn, unarmed people served the orders and said, somebody who carries a gun is going to be buying it pretty soon, maybe today, to pick them up. Imagine what happened in the gap between visit 1 and visit 2. As other people have said, it needs to be done as quickly and with the highest degree of certainty that it possibly can. To your question, California has done a great deal already. If the evaluations are done at the population level, as I mentioned for APS, and given that everything we're talking about here today is an incremental change, the fundamental difference between us and other states is we have gun violence restraining orders and a robust, comprehensive DV restraining order law. We're talking about incremental change here. Documenting an impact of incremental change at the population level is really difficult, and most of the time you can prove in advance that it's not possible to document, so you shouldn't try. But just the statistical power won't be sufficient. So that involves, that requires that the evaluation be done at the individual level. We're actually trying to do that with a couple of counties, but it means the outside researchers, in this case us, working with an array of local law enforcement agencies and the prosecutors and the courts, trying to link records that those agencies themselves can't link in order to track an individual person through and look at impact on outcomes shy of arrest, which infrequently occurs. So it's really tough. And I say this as a researcher, but also as somebody who's interested in making the world a better place. There are going to be times, and we've encountered some of them, where we may need to proceed on the best evidence we have and our expertise and just implement.
And your intuition is that just to summarize what you just said there, no, we don't have evidence this is going to make a significant change, but your hunch is that it will.
Yes.
All right. Tom, and then I'll let Senator Skinner close out this.
I wanted to ask about a related topic, so I defer to Senator's question, and maybe we can come back to me.
Thanks. So Julia opened this with her comments with referring to a really tragic situation which just happened in my district in the city of Alameda. And Alameda, as I mentioned, is one of my cities that most embraced the GVRO and has really been working to and has issued more than most of my other cities, which again is a very small number, but still. Okay, so what I want to ask, and I'm asking this of the Santa Clara DA's office folks, you know, we don't know the circumstances yet of that, what happened there. But I would guess that it was either a domestic violence. There was some evidence of domestic violence in that household, whether ever reported or not, I don't know. Or some potentially, perhaps maybe some mental health issues with the husband. But there's, in other words, I would guess that one of our firearm relinquishing orders, whether it's the DVRO or the GVRO or something else, probably had people around this individual known about it, might have been used and might have been able to prevent it. So making those assumptions, knowing that that's a big assumption, but what would you do in your jurisdiction to help ensure that it's used in a way to prevent that? What other steps would you take to make sure that these kinds of circumstances result in people knowing about these orders and utilizing them?
Thank you for the question. And also thank you for everything you have done to give us the tools we need to use them. What we do in our jurisdiction, domestic violence, and by the way, this domestic violence is a very specific, unique animal. And what we know about it is the high lethality of an armed domestic abuser. And so at all domestic violence arraignments in our county, we ask about firearms. We make a person prohibited from having firearms at the moment of their arraignment. The reason that this is important is that I don't think that most jurisdictions are doing that. And it does require effort on our part to leverage the available tools that you all have put into the code for us and the systems that are available to us in California. So what we do is when a person comes onto the radar for everything from a misdemeanor domestic violence offense on up, we know they're likely to be out of custody pending the adjudication and eventual possible prohibition from an offense. But during the pendency of that case, we immediately issue a criminal protective order, which makes them prohibited. We then run them out for firearms, for registered firearms. We then ask about unregistered firearms, but known firearms. So maybe there was a firearm involved in the incident. And then if we learn that this person is armed and now prohibited, we have a team in our county, a gun violence task force that is able to actually go do something about it. And all of those things, by the way, take time, money, effort, resources. And that is something we are very privileged in my county to have those things. But this happened because we have always been really kind of invested in domestic violence. Let me just say that same practice is not going on at every felony arraignment in the non-domestic violence context. And it is a huge area for improvement that at a felony arraignment for a violent gun-involved offense that we would be on the ball in that same way. We're working very hard. Mike carries the torch forward to do that. But this is something with existing laws we can and should be doing when somebody comes onto the radar of law enforcement from a prosecutor side. That's on the court side. Honestly, Every bit of time that I spend with police officers is the best use of my personal time, in my opinion. When I go to a patrol briefing and I say, hey, here's what happened yesterday in Alameda, how are you going to prevent that in San Jose today? When you go out to the scene of a DV and you think that there is a gun involved, you are going to initiate, you are going to ask the victim if she wants a domestic violence restraining order. And if not, and if there's a fear of a firearm, you are going to get a gun violence restraining order. Because honestly, our cops are best situated to assess and address risk. So thank you for the tools you gave us. But again, it's implementation, it's dedicated people, it's education, and it is attention to risk. And that is a hard thing to do. It takes years.
Thank you. We're running close to the end of the time, so I want to just hear quickly from Dr. Wittermute and then Ms. Weber, and if any of the committee members, Tommy, if you wanted to chime in with your question too, then let's wrap it up.
In response to Senator Skinner's question, we've done a bunch of large-scale survey research here in California on the general population, looking at levels of awareness of GVRs, but most importantly, looking at willingness to be involved and at barriers to being involved. So some of them are obvious and some of them are not. And I'll make that research available. I think it would be helpful in crafting any sort of policy that's going to work at the community level on this.
Thank you.
And I was just going to comment first with respect to, do we know this makes a difference? We often cite the 16% reduction in domestic violence homicides when firearms are relinquished. So just in support of the Dr. Wintonmute's earlier statement about April Zioli's work, the difference is not just having the policy, it's actually the relinquishment procedure. So we actually do have evidence that removing firearms reduces risk, and that the presence of firearm increases the risk of lethal outcomes and serious injuries significantly. So removing firearms, and that speaks to the issue that Senator Skinner raised, which from all reports so far, this family had no contact with the criminal legal system. So with all of the good procedures in place in Santa Clara and elsewhere, that family may not have any reason to have found themselves in, even if they knew about civil restraining orders or criminal procedures. But we have to counteract the notion that you are safer with a firearm, the notion that the industry is putting forth, that you are safer, that victims and survivors of domestic violence are safer with firearms than without. And we can do that in a variety of ways. So I do think that it may or may not be within the purview of the commission to focus on this, but better education and information about the risks associated with the presence of firearms and treating firearm access and violence as a public health crisis, one that schools have to address, social services, so that even if someone is in a batterers intervention program or getting counseling, I spent a lot of time educating mental health practitioners and folks who interact with families in crisis so that they integrate an understanding of raising, not just when you go to your pediatrician. I keep hearing from people, I get more questions about whether I put sunscreen on my child than if I have firearms in the house. Both are important, and one of which is more likely to result in a lethal outcome. So let's, be supportive of projects like the Bullet Points Project out of UC Davis and elsewhere. We have a toolkit coming out through Pierce's pledge on encouraging those who interact with families who are involved with child custody matters to have conversations about removing firearms in contested child custody cases to reduce risk. So maybe this family could have benefited from some information because there's some evidence that they had multiple firearms in the house. So the presence of firearms and removing those firearms can really help address the issue.
Thank you. Tommy, I'm going to go to you. Hopefully that addresses the issue that Ari was going to say at the end, and then let's wrap up this panel.
Yes, I just wanted to ask and hear from folks, this is something we've touched on a little bit, a very specific data integrity issue. When we looked at the data and apps, it looks like there's a lot of folks in apps where the investigation is essentially closed because it seems like perhaps they don't have the firearm anymore. And we're talking about sort of limited law enforcement resources and things like that. And Julia, you talked about the form the Department of Justice has saying, I lost the gun or it was stolen or, I don't have it anymore. And I wonder if, and this is one of the things we thought, and we heard this from a couple people when we were talking about this, that actually trying to resolve the issue of I don't have the gun anymore right after criminal conviction might actually help preserve some of these law enforcement resources, because then you're not going to end up in apps. Apps is another investigation, and the 5 cars driving around can spend their time doing something else. So I'm curious for quick reactions if that seems something fruitful that the Penal Code Committee might want to focus on.
I mean, absolutely. So I spent a lot of time training judges and court staff on this, and one of the main questions that those folks ask me is, what do I do when the defendant or the respondent in a civil or criminal matter says, I don't have that firearm? AFS, the automated firearm system, says I do. I sold it in 2001, or it was stolen, or I gave it to someone. I don't have it anymore. And you first have to assess the credibility, of course. Every contested litigation matter is a he said, she said. It's not particular domestic violence or these matters. That's what we train our judges and lawyers to handle. So assess the credibility, and that form is signed under penalty of perjury. And if that form is filled out correctly, entered into the system correctly, which is an issue, we got to enter these, I mentioned this in my written comments, we have to enter these orders, and we have to follow through to improve data integrity and ensure enforcement and appropriate follow through, then we could hope that that information would be cleared up. Because absolutely, I mean, those of us who are concerned about reducing gun violence aren't interested in having investigations, arrests, or prosecution of folks who don't need to be put through that whole process, and resources could be better spent. So I don't want to put it all in one form, but there are procedures that are associated with those forms. And, you can't help but be a fan of forms when you've worked at the Judicial Council for as long as I did.
All right. Ari, did you have any last closing comment you wanted to add?
Sure, I can do this in 10 seconds. I think I just wanted to clarify. I think many of us were calling for more protocol development as in the penal code as the bridge between policy and implementation. I just wanted to pull out that I think we're talking about multiple protocols, or we're talking about protocols for obtaining protection orders. Marissa talked about the importance in Santa Clara of prosecutors consistently obtaining criminal protective orders in cases where a victim is at risk. So I would love to see more protocol development as we have in the GVRO. For some DVRO cases, prosecutors shall have protocols about when they will consider obtaining criminal protective orders. There are some cases where they're already required to under the penal code. Many of them are buried, and I would love to see plain language protocol development around prosecutors, law enforcement, and others when they will obtain protective orders and how they will make that assessment. And we're talking about, once those protective orders are obtained or another firearm prohibition is issued, what is the protocol for enforcement and implementation of that protective order? So on the front end and on the back end to ensure that these processes work. So then we're talking about the protocol for ensuring that these orders are served. They can't take effect. No one is safer until it's actually served. That is a known gap. So served and enforced, so that the firearm is recovered at the point of service, and that if it is not, there is follow-up compliance. So just wanted to tease that out. I think we're talking about recommending protocol developments across all of those important different components of this.
All right. That's very helpful. I appreciate it. I think that people seem to be very much on the same page, and I think that was a succinct summary of what we're up to. Or the challenges ahead and recommendations from you all. Thank you all very much. Again, we might very much appreciate it. As I said with the other panel, we hope that this remains a two-way street. If you have ideas for us, we promise to be back in touch with you. If we have further questions, please don't be strangers. I'd like to take a 5-minute break between this panel and our next panel. So let's break until 11:55.
Thank you for your work.
Okay, thank you. Thank you, everybody.